Hey everyone, I'm Mr. Willis, and welcome back to You Will Love AP Gov. Thanks for joining me for another video on one of the required Supreme Court cases for AP US government. Today's video is all about Shaw versus Reno, a case that addressed racial gerrymandering and limits to redistricting under the Equal Protection Clause. If you're taking notes for your AP class or prepping for the AP exam, remember to click on the link below and download the free guided notebook page to make it easier to follow along. Let's break it down. The case arose after the 1990 census, when North Carolina gained a 12th congressional seat due to population growth. The state legislature initially proposed a redistricting map with only one majority black district. The U.S. Department of Justice rejected the plan, urging the state to create a second majority black district to comply with the Voting Rights Act of 1965. In response, the state submitted a new map creating an unusually shaped second district, stretching along highways for nearly 160 miles, at times no wider than the road itself, designed almost exclusively based on race. 5 white voters from North Carolina, including Ruth O. Shaw, filed suit, arguing that the bizarre shape of the district violated the Equal Protection Clause of the 14th Amendment by segregating voters based on race. The legal issue before the court was, does a congressional redistricting plan that creates a racially gerrymandered district violate the Equal Protection Clause of the 14th Amendment, even if it was created with good intentions to enhance minority representation? In a 5-4 decision, the Supreme Court held that yes, race-based redistricting must be held to a standard of strict scrutiny under the Equal Protection Clause. Even if the intent is to remedy past discrimination, creating districts where race is a predominant factor can reinforce harmful racial stereotypes and undermine the ideal of a colorblind constitution. Justice Sandra Day O'Connor wrote the majority opinion. She acknowledged the importance of the Voting Rights Act, but warned that bizarrely shaped districts drawn solely to concentrate voters of one race could imply that elected officials represent only members of a particular racial group. She emphasized that such racial classifications must be narrowly tailored to serve a compelling government interest. Shaw versus Reno set a major precedent. Racial gerrymandering, even when done to improve minority representation, is subject to constitutional limits. The case did not outlaw majority-minority districts outright, but required states to consider race carefully and avoid using it as a primary factor in district design without strong justification. Today, Shaw versus Reno continues to impact how states draw legislative maps and how courts evaluate claims of racial gerrymandering. It serves as a crucial balancing point between the goals of racial equity and the principle of equal protection for all citizens. The decision remains a cornerstone in the ongoing struggle over voting rights and fair representation. Shaw versus Reno reminds us that even well-meaning attempts to enhance minority voting power must still conform to constitutional standards. And that's everything you need to know about Shaw versus Reno. You can click here for additional videos for AP US Government. And be sure to check out my videos on AP Macroeconomics and AP Microeconomics as well. If you found this video helpful, be sure to like, share, and subscribe for more content on AP Government and Economics. Thanks for watching. I'll see you next time on You Will Love AP Gov.